All right, everybody, welcome to Better Call Paul, Thursday, May 21st. On behalf of Trident Title, Performance Title and Escrow, and Synergy Title, we have here our guest, Paul Krasker, who's our attorney in all three title companies. Today, we're going to be going over the as-is contract, the most recent version, which was updated June 2019. Paul's going to take us through that. We're going to dive into a couple different spots that he wants to make sure we touch on. If you do have any questions, please save them to the end, and we're going to get it popped up here so you guys can see it and read along right where Paul is going to be talking. So, Paul, thanks for being on. Let me know what line, where you want to start, and I will head us over that way.
Great. I'm just going to hit the highlights since we have 1 hour, and this could be called common mistakes in filling out the as-is form as opposed to a contracts class. So I'm just going to run down quickly. Paragraph 1D, there's a line there. I don't see a lot of people filling it out. If you are representing a buyer, I think you want to add in a few different things that aren't standard in the contract. I would add in on line 20, security system, washer and dryer, and then I would add anything else specific, but then I would also add language that says, and all as per MLS listing, as a catch-all. If the MLS listing says that there's a water filtration system, then they shouldn't be able to take out the water filtration system. If the MLS says built-in entertainment center, then they shouldn't be able to take it out just because they could unscrew it and patch the holes. So you want to be clear now so that you don't have problems later. Similarly, in line 23, if there's something that's supposed to be excluded, it should have been listed in the listing agreement, it should have been in the MLS, and it should be in line 23. I will jump down to paragraph 2B. There's a blank in line 35, and I see a lot of people just automatically putting 5 days, 7 days, whatever it is in there. That should be 1 day after the inspection period ends. So if you've got a 7-day inspection period, that additional deposit should be due on the 8th day. If you've got a 10-day inspection period, have it be due on the 11th day. But always remember that should be tied to the inspection period. And if you extend the inspection period, you should also extend the time period for the additional deposit. I see a lot of agents getting caught there where it's a 10-day inspection period. They ask for a 5-day extension. You write in an addendum that says the inspection period shall be extended for 5 additional days. And then the seller turns around on the 4th day when the buyer tries to cancel and says, I want a confirmation of the deposit amounts. And then the broker realizes, or the agent for the buyer realizes, oh my God, my guy should have put up the second deposit already, didn't do it, and now we're in default and the seller's going to make a claim on our deposit. That's happened twice in the last year, so please be careful and tie that together. The other thing I always mention to everybody, line 38 on the financing, if you're doing an 80% financing, please know that you could put in the percentage amount there and you don't have to put in the dollar amount. The benefit of putting in the percentage amount is when people negotiate the purchase price up or down, you don't have to remember to adjust the financing amount. And you can always put balance for line 41. Okay, I usually ask this as a question of everybody when I have you live in the room, but I just want to remind people today that line 48 and 49 tell people when the effective date is of the contract. Hopefully all of you are using your KW systems, and the electronic signatures are sent to everybody, so delivery is not an issue. But the effective date of the contract is the date when the last of the buyer and seller sign and deliver the contract to the other party. So if you do have somebody who's emailing back and forth with contracts, remember that you have to deliver it to the other realtor before the contract becomes official. I'm going to jump over to page 2. I want to remind everybody on paragraph 6A, the standard for occupancy. Ryan, you want to scroll down a little bit to 6A? Perfect. Is removal of all personal items and trash from the property. That is a different standard than the old standard of broom swept condition. You do not have to have it broom swept. If there's little balls of dust in the corners, you can't stop a closing for that. You can tell people if they haven't removed their personal items and the trash that you will escrow 125% of the cost of removing those items, so that if it's not out before the closing, you have 125% to take it out at the seller's expense. Paragraph 7, I never check the first box. Most of the time I'm okay checking the second box, which is assigned but not be released from liability. There are very few times that you should be insisting on not having it assigned at all, but some sellers do insist. Okay, I'll spend a little bit of time on paragraph 8B. You could see that in line 91, you're supposed to apply for the financing within 5 days. That is now a specifically defined term. That means that the buyer has to have signed the disclosure documents to formally apply for a loan. If those disclosure documents are not signed within the first 5 days, the buyer is in default under the contract, period. So there have been a lot of sellers who are trying to get tough with people in these times and force them to either lose their deposit or close, and don't make the mistake of waiting until the end of the inspection period to apply for a loan. If you are going to wait till the end of the inspection period to apply for a loan, then in line 91, you have to change that date. Instead of leaving it blank and letting it be 5 days, if it's a 10-day inspection period, you need to say within 11 days after the effective date, they will apply for and pursue a loan. I've had a lot of questions on, can you get out of a contract and get your money back if you've applied for a loan and you got approved for the loan, but for some reason the bank rescinds that approval. If you look on the top of page 3, perfect, thank you. If you look at the top of page 3 in lines 116 to 121, those identify some reasons that the buyer can still get out and still get their deposit back. So if the appraisal comes in low, and it is low enough so that it is insufficient to meet the terms of the loan approval, the buyer can get their deposit back. If there are property-related conditions that have not been met, most of the time it's, you know, the electrical needs to be up to code. We need verification that the electric's up to code, or that the roof is structurally sound, something like that. But what I've had a lot of in the past 60 days is condo issues. People are buying in a condominium. They don't get the condo questionnaire until 5 days before closing. The lender says, listen, there's 20% rentals in there, or there's no reserves in the building. Those are considered property-related conditions, and the buyer gets to walk, and the buyer gets to keep their deposit in those circumstances. So push to get the condo questionnaire filled out. If it's a condo and there's a loan, even if you're the listing agent, push that condo to get the condo questionnaire over to the lender as quickly as possible. Ryan, any questions on the things I've covered so far?
No, no questions yet. You're still good.
Terrific. I'm going to jump over paragraph 9F in the middle of page 4.
Okay.
This is the special assessment clause. I'm getting a lot of questions about this. This has nothing to do with condominiums or homeowners associations. This is special assessments from public bodies only. And there are 2 boxes that you can check. If you don't check either box, then it's deemed that A will be binding, which is seller shall pay the installments due before closing, buyer pays it after closing. I'm going to give you a perfect example of what this is. The town of Palm Beach passed an underground utilities special assessment. You had a choice to pay it in full up front or pay it off over 10 years on your tax bill. For those people who paid it off for 10 years on their tax bill, if the buyer doesn't check box B, which every buyer should check box B, then if they don't, then the seller's going to pay for the first 2 years of the undergrounding, and the buyer's going to pay for the next 8 of the undergrounding, or whatever it falls into from the time period of closing. If you check box A, if you check box B, rather, then whatever's left in the special assessment has to be paid in full by the seller at closing. So perhaps Wellington is different, or Royal Palm, or wherever you're farming is different, but there are opportunities, whether you were on a dirt road and they paved it, or they just put in street lights in your neighborhood. Those are now things that are getting specially assessed per your subdivision. They have the ability to go on the tax bill if you so choose. Those are considered the special assessments. The condominium special assessments are dealt with on the condo rider. Here's a quick heads up. The homeowners association rider does not address special assessments. If you want to address special assessments and there's a HOA, then you have to address it in paragraph 20. You have to say any special assessments that are issued by the HOA prior to closing will be paid for by the seller, period. All right, I'm going to run down the disclosures. Keep in mind under these disclosures, if you're a realtor and somebody asks you about the property tax disclosure summary, what's the taxes going to be next year, you want to be very clear. You want to say, you know what, I'm happy to go to the property appraiser site, type in this property and send you what the property appraiser thinks your taxes will be based on the purchase price. But you don't want to give them a dollar amount based on the seller's taxes because they may be homesteaded and the number may go way up. Let's see, paragraph 11. Please, please, please don't tell your sellers that they have no obligation after they sign the contract. Do not allow them to cancel their landscaping contract, their pool contract. When the buyers come to the house for the walkthrough inspection, If the appliances don't work and they worked when the contract was signed, the seller has an obligation to put them into working order or to replace them. Paragraph 11 is very clear, and it's also clear that the lawn, the shrubbery, and the pool are included. If they get there and the pool is green, they have to not only replace the pool systems that are making it green, but they actually have to have the pool clean and in working order.
Paul, on that for 11, I just wanted to add in, because you helped me with this on a flip. I think it was right around Christmas or New Year's. Even for investors, this is something that comes up. So if you go into a property and you know it's going to be an investment, that still doesn't give the seller the ability to just stop caring. In that example you did for me, we had went under contract in October. We were set to close right around New Year's, and they stopped doing any maintenance on the property, and leaks got worse, and things on the exterior got worse than they were, and we were able to negotiate again because of that. Paragraph 11, and I bought a lot of flips and didn't know that, and you had saved me a bunch of money just by telling them that.
Sure.
That was amazing to me. So if you guys are working with investors, keep that in mind, that even if you're buying a property that's in disrepair and for a flip or a rental, they still have to maintain it to the last line of that, in the condition existing as of the effective date. So if it's 2 months before it closes, so many things can change on that.
Yeah, and Ryan's right. The best thing in the world is when people take all these great artwork, photos, and video and put it on the MLS system. Remember to print those out or download those to your computer as of the date that you're making an offer, because that's Exhibit A on whatever mediation or litigation or arbitration ends up coming down the line, because they can't tell you that the property wasn't in great shape when they've done a video showing you the property was in great shape.
Yeah, that was huge. That was something I never knew. Learned a lot there.
Just a little point on the top of page 6, paragraph 12D. Not a lot of people do this. If you're representing a buyer, ask the questions about whether there are service agreements. Is there a termite bond? Is there a service agreement? Are there maintenance contracts that exist? Those are assigned without cost or expense at closing. It makes you look good if you didn't know anything about it, and all of a sudden at closing, you're assigning over the warranty contracts for the air conditioning system, the bond for the termite repair, and a service contract for the last 4 months or whatever it is of the existing contracts. Let's see, a buyer default. I'm going to go to the top of page 7. I'm encouraging people to absolutely remove the language at the very top of page 7. They should cross out on line 329 and 330, or seller at seller's option may, pursuant to paragraph 16, proceed in equity to enforce seller's rights under this contract. Just, if you represent a buyer, cross that out. Do not give the seller the ability to sue you. The worst case scenario that should have happened in all of these disputes for the last 45 days should have been the buyer walking away from its deposit. But if you didn't cross that language out in your contract, you were leaving your buyer open to a lawsuit to have the seller say, well, we were under contract for $500,000, and now I'm going to have to sell it to somebody else for $400,000, and you owe me $100,000, plus you owe me the carrying cost of the unit, etc. So you absolutely want to cross that language out. Similarly, if the seller defaults, the seller might want to remove the language that cross out the word without in line 335. and might want to remove the language in the next line down where it says recover such damages or. Same kind of theory. If the buyer's limiting their liability, the seller can limit their liability. You don't want a buyer suing after closing. You want the buyer to decide to take the deposit back or to seek specific performance, but you don't want some buyer being able to sue for damages. Okay, and in that regard, I've had a couple of instances, even in the last 45 days, where agents negotiated a release of deposit money, but handled it via email and didn't have the release and cancellation form signed. Please, please, please have the release and cancellation form signed. You don't want to be in a situation where there's liability post escrow disbursement. When that escrow is dispersed, you want everybody to walk away forever for no reason. Can anybody come back? Okay. Also, in paragraph 16, just want to make sure that everybody understands there is a 10-day cool down period before you can go to mediation. If there's a dispute and the parties are fighting, you know, the stupid letter that goes out every time is, if you don't give me my money back, I'm filing suit for tomorrow. You couldn't do it if you tried. You have to wait 10 days. You have to go to mediation. If the mediation doesn't work, then you can go to litigation. But you need to go through the mediation process first, and you can't do that for 10 days. There's a really good reason for that, because most of the time within that 10-day period, people cool down and cooler heads prevail and they can work something out. Okay, let's see. I'm going through the standards. I was going to cover standard 18D. If paragraph 6B is checked, which means that you're buying this property subject to an existing lease, paragraph 6B says you have to give them a copy of the lease, and they have 5 days after review of the lease to terminate the contract. Similarly, in 18D, they have 5 days after they get a tenant estoppel letter to review it and cancel the deal as well. So if you're a listing agent, you want to have the lease and a tenant estoppel letter signed by that tenant and deliver it right after the contract is signed, so that these two contingencies are over, these 5-day rights of cancellation are over before the inspection period is over, so that you don't leave a loophole for a tenant to respond and the buyer says, you know, I don't like this estoppel letter, and you turn around and say, well, geez, I'm the listing agent, I don't think there's anything wrong with it. And they say, I don't even care what you think. I have a right to cancel 5 days after getting it. I got it. I'm within the 5 days. I'm canceling. Give me my money back. But the tenant estoppel letter, and if you don't have tenant estoppel letters, I think the RAPB has a simple form that people use. Trident also has forms, and Performance also has forms, so we can get those to you. But it's basically making sure that the tenant says what the security deposit and last month's rent is, that they don't have any claims against the landlord, that they don't have a right to purchase the unit in their lease that somebody's forgetting, et cetera, et cetera. Let's see, a time period under the contract below there. You know that this is all calendar days. If a time period ends on a Saturday, Sunday, or legal holiday like Monday, it is extended till 5 p.m. on the next business day. All other days, the time period extends till 11:59 p.m. So if you're waiting for somebody to cancel, don't be smart with them and turn back to them at 5:10 and say, now you can't cancel anymore. You're stuck in this contract. You need to send me the rest of the deposit, and then find out that they cancel 10 minutes later. Force majeure, I think we've gone over this enough over the last few days, but remember that it is not a right of cancellation unless 30 days pass with the event that caused the force majeure still in existence. There are about 10 lawsuits that I'm aware of that will bubble up through the legal system over the next 2 years or so that are going to be addressing deposit money held in escrow. I know one of them down in Broward County that's about a $250,000 escrow. I don't think the parties are going to let it go, and I think that we'll probably get some case law from the 3rd district. I haven't heard of anything in the 4th district yet that's been filed, but it is bubbling up, and in about 2 years, we'll have a better sense of what is and what is not force majeure. Let's see, just going through the back end, want to make sure that everybody on the FERPTA, bottom of page 10, understands that there are new FERPTA rules. If it's under $300,000 and your purchaser is willing to state that they intend to use the property as a personal residence for 50% of the time in use for the next 2 years, then there is no withholding. If it's $300,001 up to $1 million, and the purchaser is willing to say that they intend to use the property as a personal residence for 50% of the time in use for the next 2 years, the withholding is 10%. If the buyer is not willing to say that, it jumps to 15%, and it's 15% above $1 million no matter what the buyer is willing to say. If the buyer is willing to play ball and say that their intention is to use it as a personal residence, write that into paragraph 20. Don't make the mistake of leaving it until closing and just accepting an oral representation. Write in that sentence to paragraph 20, because what happens, especially with the as-is contract, is the buyer turns around and says, I've done my inspections, I want a $15,000 credit. The seller says, no way, I'm already selling this below market value. I'm not negotiating with you. Buyer says, fine, I'll close the way it is. And then at closing, they won't sign the affidavit for the FERPTA, and they won't say that they intend to use it as a personal residence for the next 2 years, just to stick it to the seller. And the seller turns around and says, what are you talking about? You agreed. And they say, yeah, too bad you didn't give me the $15,000. If you give me a $5,000 credit, I'll sign the affidavit now, but otherwise I'm not doing a thing. So that's the issue there. I think that most of the offices have standard language that they write in on paragraph 20 now, something to the effect of seller shall close out any active, inactive, or expired permits and address any code violations or HOA violations prior to closing at seller's expense. If that's not in there, you certainly want to write that in there. I think that's all I'd like to go over with the contract. Again, it was more of what I see as the big mistakes these days. And then I wanted to allocate some time. It's 4:36. to answer any contract questions.
Perfect. Paul, I have a list of questions, so I'll read through them, and if they're based on a line or somewhere, I'll try and pull that up also so that we can follow. I'm going to start from the top. If anybody else has any questions, please just type them in the chat, and we'll go through them one at a time. We got enough time here. Okay, number one, HOA docs. When are we required to provide to the buyer if you have the listing? So this person's the listing agent, and when do they have to apply or give the HOA docs to the buyer?
All right, it's a trick question. You're trying to stump me. The right answer is you don't have to supply the HOA documents. The HOA rider is very, very different from the condo rider. The condo rider says you have to deliver the condo articles, the bylaws, the declaration, the rules and regulations, any amendments to those. You have to give them the frequently asked questionnaire. You have to give them the 2019 financial statement. And if you miss one of those items, they can walk away at any time. The HOA rider basically says, hey, you're in an HOA. You better go get a copy of the HOA documents because you're going to be bound by them. And they make the onus on the buyer to go get those during the inspection period and make sure they're comfortable with everything.
Great. Next, is there a way to confirm if there are municipal assessments before we place an offer? I know that was, you were talking about that earlier.
So there are many municipalities that do have special assessments outstanding. One of the ways is that you could go to the tax, the PAPA tax bill. You can look at the non-ad valorem tax situation, and you'll see in there, like if you go to the town of Palm Beach, pull up any of the properties that had the taxes spread out over 10 years for the town of Palm Beach, you'll see the underground assessment as listed in the non-ad valorem area. If you're not familiar, you can always call the finance director of whatever municipality is and say, I'm looking in this subdivision, are there any special assessments?
Great, thank you.
But the safest thing to do is just checkbox B there.
Perfect. Someone asked where, when you were referencing paragraph 20, where is that? I'll show that on the screen. So paragraph 20 is all the way down here.
That's the fill in the blank you choose additional terms paragraph.
Okay, line 183. Let me pull back up to here. Line 183, I've had agents insisting on box A to be checked instead of box B. How are you addressing this? I think you kind of covered this, but.
Yeah, so it's a theoretical discussion, right? It's if they just put in streetlights on your street and it's been 1 year since the streetlights were put in, technically the buyer's going to get all the benefit from it. And so it should be fair for them to pay in the future. I look at it very differently, and I say, if there's a municipal special assessment, you should have disclosed that to me up front. I bought on this street thinking there were streetlights and not realizing I was going to have to pay for my own streetlights. And so I insist on B and say, no, if you think there's a municipal special assessment, go tell me what it is. But you should have disclosed that in your listing agreement, and you should have disclosed that on MLS. I don't want to find out I'm paying an extra $8,000 over the next 8 years for my streetlights that I just presumed were there. So, you know, it becomes a theoretical debate.
Makes sense. All right, a lot of questions about FERPTA. I'm going to go down to that section. First one is says between lines 329 and 325. Can you explain the FERPTA withholding again? I'm going to read them all because you'll probably be able to answer all these like in one go. So 329, 320, 335, explain again. FERPTA withholding, please explain why the use of the buyer has anything to do with the sellers having to pay tax or not. A couple, please re-explain FERPTAs. So
okay.
If you could go over that a little bit.
So I'll go back over it again. You're a great question to ask. Why in the world does the buyer have anything to do with whether the seller has to withhold money or withhold it at a lower amount. Great question. It has to do with history of the act. The Foreign Investment and Real Property Tax Act was enacted in the late 80s when it was actually Japan was buying up a lot of property in the United States, and the Congress got scared that quote unquote Americans wouldn't own quote unquote America. And they created this act, which was originally supposed to be designed as a database to know who was buying what. Well, when they figured out how expensive that was going to be to create this national database, they quickly abandoned that side of the act and said, nah, that's not really what we want to do. What we really want to do is just make sure that when foreigners are selling and they're supposed to pay their real estate tax, their capital gains taxes on the profits from the sale of their real estate, that we have some mechanism that we can ensure that they are paying their taxes. So that's how the FIRPTA withholding comes into play, that we want to make sure that we're holding enough money to cover their taxes so we don't have to go chase them in Canada or China or Japan or Italy, because it's just not effective for us to file lawsuits in jurisdictions that we don't have any authority. So we make sure that we keep the money in here with the IRS and let them come back and try to ask for it back in a form of a refund and justify their refund.
Awesome. Makes sense.
When you were asking, how does the buyer impact this? Well, for the small deals, which are under 300,000, the presumption is that there isn't much taxable profit anyway, and it's a real pain to do it. But they wouldn't just say under 300,000, there's no tax whatsoever. We'll just let people walk away from it. They came up with this concept, and again, it's that xenophobia that you had in the 80s and the 90s, where they said, we want Americans to own America. And they instituted this rule that said, well, if somebody's going to make it their personal residence and they're getting a foreigner out and they're going to be there, then that's worth it to us. So if this is going to be your personal residence and you're an American or you're a green card holder, then we're replacing a foreigner with an American, and that's how they justified walking away from that revenue. It's really stupid.
All right, 2 questions on default. 329 and 3. So I guess it's seller default. Basically, just explaining these 2 parts again. What does this mean? The buyer. What did you advise them to scratch out on 329 and 330?
Sure. So if the buyer defaults, the buyer wants to know that the seller gets to keep their deposit as liquidated damages as their sole remedy. But at the top of page 7, in lines 329 and 330, the seller has this alternative remedy that they can pursue, which is scary. And if I'm a buyer or I'm representing a buyer, I don't want the seller to have that alternative remedy. So I want to cross out the words, or seller at seller's option may, pursuant to paragraph 16, proceed in equity to enforce seller's rights under this contract. I want to cross those out and have the buyer and seller initial that cross out. And what that does is it leaves the seller with an appropriate remedy. They get to keep the deposit and cancel the contract. And that's it.
Great. And then the same thing on the seller one, you had advised them scratching out a couple lines on the seller side. I think it was 335.
Right. So if the seller defaults, and I've had a couple sellers who defaulted during the coronavirus and said, hey, I'm just not leaving my house. I don't feel comfortable moving to another place or signing a rental when I don't know who's been in there. I am I am not closing, you want the buyer to have two remedies. They can either sue for specific performance and say, no, 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 you are going to sell me that house at that price, period, end of story. And they get to recover their attorney's fees again, pursuant to the contract, a little lower. I think paragraph 17 allows that. But so they can either get specific performance and get their attorney's fees covered, or they can walk away and just take their deposit back. Those are the two options for a buyer. But this contract gives the buyer a third option. They can take their deposit back and then sue the seller for damages. And that becomes a problem because the seller's never free. You know, you thought you were getting away. You thought that everybody agreed on what's going to happen. You're going to take your deposit and go find another place. But then 4 months down the line, all of a sudden you get a lawsuit. And I'll give you an example of what happened to me once with a client that I was representing as a seller. She was living in a subdivision. There were 16 homes around a lake, and she had 3 children. She became pregnant with a 4th. She was no longer able to stay in this house because it was just too small for 4 kids. Put the house up for sale, and prior to giving birth, she was diagnosed with stage 4 cancer. She decided that in the midst of having to fly around the country trying to figure out her treatment options, what to do about the baby and the cancer and all this stuff, that she just couldn't go forward with the sale of the house, and they would just have to live there and deal with it later. The realtor notified the other side. The other side sent an email saying, great, just send us back our deposit. We'll find another house. The listing agent made a mistake and didn't get a release and cancellation signed. She just had her office, who was holding the escrow, wire back the money. And a month later, while this woman is going through her cancer treatments, gets a lawsuit handed to her saying, I had to buy a house 3 doors down. It cost me an extra $50,000. You owe me the $50,000. That's what you want to try to avoid by crossing out the word without on line 335 and crossing out the words recover such damages or on 336.
Wow. That's a great example. Well, not, but it's a valuable example.
Yeah, you know, the funny thing is I took that case pro bono for the seller just because I thought the buyers were being such jerks. And one of the arguments we made was that you actually got a better deal on the other house because there were so many upgrades that were worth far more than the $50,000 that you shouldn't get any damages. And the judge, who hated the other person for having filed a suit under these circumstances, gave the judgment to me and awarded me attorney's fees on the other side because of the contract attorney fee provision. So
I love that.
They got theirs in the end.
Good. Karma gets people sometimes.
Yeah.
All right. I was under the impression that an agent cannot cross out any lines in the contract, only the attorney. I'm confused.
Totally untrue.
Okay. Clear. Diane said, is that not addressed in title search? I'm assuming that was while we were talking about something. I'm not exactly sure which part that was for. So Diane, if you want to come back in on that, jump back in. Another one, what are the recommended items to include in the additional clauses at the end of the contract? You had said it before, what you were telling people to put in with like the clearing permits and closing out things. Can you just say that again?
So I don't want to go against any recommendations from any of the offices. So if you have an office that has specific approved language, certainly use that. The language that I often give to people to insert is, and I'll just read it off, seller shall close out any active, inactive, or expired permits and resolve any code violations or HOA violations prior to closing at seller's expense.
Great, thank you. Effective date, does the agent have to acknowledge receipt of the contract for the effective date, or does it just need to be delivered?
You know, if you're sending it, if you're hand delivering it and dropping it off at somebody's office, I would make sure they acknowledge receipt. Whoever's at the reception desk, just have them sign an acknowledgement. If you're doing it like most people are doing it, electronic delivery, you don't have to worry about it. If you're emailing, you know, maybe send it with a read receipt so that you know when it was sent and you know when it was read. But yep, best
Makes
practice.
sense. Do those who sue for specific performance usually win? I think this was in regards to the buyer and seller default.
Yes. If you want to enforce your contract, you do. You know, usually though, people get bored. Nobody likes litigation. It's not fun for anybody. And what do they do when they file suit for specific performance on a given house? Unless they absolutely have to have that house, they look in the neighborhood that they were interested in and they find another house and they see that that's available at the same or better price, and they call the other side up and say, if you give me $20,000, I'll buy the house next door. And many times that's how those suits are resolved.
Got ya. And then you have a great neighbor who you just had to give $20,000 to. That sounds awesome. Looks like last one, line 337. Can buyers still seek specific performance? 337. Yes. I think that's with the seller default part.
Yeah. So remember, if the seller defaults, there always has to be a remedy for specific performance for the buyer, or else it's not a valid contract. So that's always a remedy for the buyer, is specific performance, and you can't cross that out. If you cross that out, it's not a valid contract. The only thing that you can cross out is their ability to sue for damages in lieu of just letting you walk away.
Got it. All right, that looks like it. Last question from Nancy Jennings. Sorry, I have to leave a little bit early. Love Paul Zooms. Thank you, Paul and Ryan. All right, everybody. Thank you again for jumping on to Better Call Paul today. We appreciate this. Hopefully you got some more insight into the world of the as-is contract. And as always, if you need anything, need any help with title, insurance, settlement, anything like that, always jump on these Better Call Pauls. And please, if this was valuable to you, continue working with us at Trident Title, Performance Title, Synergy Title. And we appreciate you guys. See you soon. Thanks a lot, everybody.
Bye-bye.